On August 22, 1991, during his third court appearance, 1 month after his arrest, Jeff Dahmer gave up his right to a preliminary hearing.
Mr. McCann, do you wish to make an... We are represented. You have the right to a preliminary hearing. Do you understand that?
Yes, I do.
Mr. McCann, do you wish to address the issue? Is it correct that you wish to waive or give up your right to have a preliminary hearing in this case?
That's correct, Your Honor.
Is this your signature on the form telling me that's what you would like to do?
That's my signature.
At the time that you signed this form, was it your understanding that what you would be doing this morning is giving up just your right to have this hearing and nothing else? In other words, you are not giving up your right to have a trial. Is that understood?
That's right.
The waiver of preliminary hearing has the approval of the court. Defendant is ordered bound over for trial before the circuit.
A preliminary hearing is the trial before the trial. This is where the judge decides if there is enough evidence for the defendant to stand trial. So what did Jeff Dahmer waiving his right to a preliminary hearing mean? Well, it meant that Jeff Dahmer's attorney, Gerald Boyle, wouldn't have the opportunity to cross-examine Jeff Dahmer's confession that contained another man's social security number. The confession also showed his client admitting guilt after being shown photos and responding with statements like, "Yeah, that looks like a guy I killed." Why didn't Gerald Boyle, a defense attorney, care about these anomalies in his client's confession? If there had been a preliminary hearing and proper cross-examination, would the judge accept this confession as sufficient evidence? If not, the charges would have probably been dropped. So, was Gerald Boyle defending Jeff Dahmer or not? Interestingly, Gerald Boyle said on TV that there was going to be a preliminary hearing and that everything would be done in accordance with the law. Gerald Boyle then did the opposite. Have a listen.
Our state, based upon the United States Supreme Court rulings, and our state had that even before the Supreme Court came down, there must be a hearing. You don't even have to ask for it. There must be a hearing to determine whether or not the person was properly advised of their rights, whether or not under all of the circumstances the statement was voluntary, whether or not it's trustworthy. If the judge decides that it's trustworthy, then the jury also has a chance to make that decision, but it's admissible then. And then the weight is to be given by the jury to that statement. All of that's going to be done in the normal process of events.
So, was this investigation thorough enough? And did the confession provide the required evidence to bring these charges forth? The answer is no.